In part 3 of chapter 1, we're going to get into the common law jury and the role of the sheriff. Back in England, the common law jury members, acting as judges of the law, were sworn to do equal law and execution of right to all the king's subjects, rich and poor, without having regard to any person, and that they will deny no man common right, but they were not sworn to obey or execute any statute of the king or of the king and parliament. Indeed, they're virtually sworn not to obey or execute any statutes that are against the common rights or contrary to the common law or law of the land, but to certify the king thereof, that is, to notify the king that his statutes are against the common law, and then proceed to execute the common law, notwithstanding such legislation to the contrary. The words of the oath on this point are these: that we deny no man common rights by virtue of the king's letters, nor none other man's, nor for none other cause, and in case any letters come to you contrary to the law, that is, the common law, that ye do nothing by such letters, but certify the king thereof, and proceed to execute the law, that is, the common law, notwithstanding the same letters. In the Federalist Papers, number 48, Alexander Hamilton wrote in part, "No legislative act contrary to the Constitution can be valid. The Constitution is, in fact, and must be regarded by judges as a fundamental law." The sheriff is a servant of the people. Upon taking office, he takes an oath to uphold the Constitution and keep the peace. In American jurisprudence on sheriffs, police, and constables, we find the following. Origin of office. The office of sheriff is an ancient one dating back to at least the time of Alfred, King of England, and the holder thereof has always been the chief executive officer and conservator of the peace in his shire or county. He's a county officer representing the executive or administrative power of the state within his county. In this country, the office is generally an elective one, and anciently in England, sheriffs were elected by freeholders of the county, although gradually it became the custom for the crown to appoint a sheriff. Abraham Lincoln stated the following: "The people are the rightful masters of both Congress and the courts," not to overthrow the Constitution, but to overthrow the men who pervert the Constitution. In volume 16 of American Jurisprudence, page 177, we read, "The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment, and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as if it had never been passed. Such a statute leaves the question that it purports to settle just as it would be had the statute not been enacted. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate to supersede any existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. The Constitution guarantees the right of the freeholder to protect his property from criminal trespass. Civil law or equity law is the law of the ruler. Common law is the law of the people. It's the sworn duty of the sheriff to obey and uphold the Constitution and to protect the property and rights of the freeborn, sovereign individuals of the county. County sheriffs must be advised of the instances where unlawful acts of officials or agencies of government are committed. It's the duty of the sheriff to protect the local citizens from such unlawful acts, even when they're committed under color of law. There's no lawful authority for judges and the courts to direct the law enforcement activities of a county sheriff. The sheriff is accountable and responsible only to the citizens who are inhabitants of his county. He's under oath of office and need not receive unlawful orders from judges or the courts. He's responsible to protect citizens, even from unlawful acts of officials of government. He should not allow his office to be used as an unlawful lackey of the courts. Since the formation of our republic, the local county or parish has always been the seat of government for the body politic, the people. A county or parish government is the highest authority of government in our republic, as it's closest to the body politic, the people, who are, in fact, the government. In the next video, we're going to show why no bureaucrat can dictate what happens to your liberty or your property.